Hello students, my name is Pooja and I'm here again to discuss about legal updates, all the important legal updates. So we have a series that is going on for legal updates since last few weeks, right? So I hope you have seen my previous videos or previous set of legal updates and you have prepared for it. Now, why are we studying these legal updates might be your question. We are reading it so that we are not set back, we don't get a setback through any surprise or unfamiliar passages in the legal reasoning section of CLAT, right? So once you are aware of all the legal developments that is going on around you, all the legal updates that is coming up every month with regard to important legal updates that has really good value in the judicial system or in the court, right? So we will be discussing more about that because that might be a favorite area for the examiner to set question in, right? So let me just share my screen and let's just start with the updates for today. Um Starting with the amendment bill, there is an amendment bill that has been introduced in the Lok Sabha with regard to the salary, the date of pension, the salary, and all of that of Supreme Court judges and High Court judges. Okay, now why is it important for us? This particular news is not important, but the background to it, all the legal background to it, is important for us, right? So there may be any passage on this basis as well, like for example, which all are the articles, what articles deal with the powers of parliament, right? Parliament is the one that determines the salary that has to be paid to the Supreme Court judges and the High Court judges, right? So which article deal with that? It's article 125 and article 221, right? So what does this amendment bill talks about? It simply says that the date of the pension that a retired judge get, right? So, there is some variation, there is some amendment with regard to that date. Like for example, there is Justice X, okay, he is getting retired on 19th of June 2022. Pehle, if we would have considered it, his retirement date or his pension should have started from that particular date, right? It should have started from that. Uh, that date has had to be considered 19th June. But now the amendment is saying that from now itself, what is happening? We are not going to consider 19th of June, but we are going to consider the first day of the month of June. Okay, from that day itself, his pension has to be calculated. Now that is not very important, but what is important is here about the articles as to which is the schedule that talks about the salary and emoluments and all of these of the governor, of speakers, right, of president, all of these. So it's schedule 2, right? Schedule 2 talks about salaries, right? So it is covered under schedule 2. Apart from that, from which fund do we pay these judges the salary, right? All the higher officials, high level people, officials, authorities of our country, most of them get their salaries from Consolidated Fund of India. Okay, now this is again important for your legal knowledge, right? So this is about one of the updates for today. Moving to the next, following what we just studied, there are certain pointers that has to be kept in mind while reading it. So I hope you just get to learn as to how you are supposed to approach a legal update. Now that amendment bill might not be very prominent or very important for us, right? But there is something that goes behind it that gets important for us, and there are high chances that there can be certain passages on this, right? These might be some few areas wherein your examiner can target you. Now with regard to the appointment of judges, Supreme Court judges, Chief Justice, and all of that, again, Chief Justice plus the judges of Supreme Court. Who appoints them? President appoints them. Under which article? Article 124. Okay, this should be on your tips. These are the few articles that should be on your tips. Okay, now what are the ages of the retirement? We just studied about the pension, right? So when do they get pension? After the retirement. So what is the age of retirement of Supreme Court judges? It's 65 years. And when we talk about the High Court judges, it's 62 years. Now these Chief Justice, right? Chief Justice is appointed by the President after consultation of High Court judges or Senior Supreme Court judges. Okay, so there is this collegium that is formed, which is headed by the CGI, right? And it has there are four other senior judges from Supreme Court that forms the collegium for the appointment of judges. Okay. Now, same is with regard to the appointment of High Court judges. Again, they are also appointed by President, but in consultation of Chief Justice of India, okay, CJI. So all the High Court judges are also appointed by President in consultation with CJI. All right. For High Court also, judges are recommended by the collegium, and then an entire process goes on for the appointment of those judges. Okay, so there are very few pointers here and there that is very important. Why is it important? Because it derives from somewhere from the constitution, right? So whenever there is any legal update that pertains to constitution, it automatically becomes important, especially these common areas of constitution, these prominent areas of constitution. Okay, you should never ignore them. Okay, moving on to the next uh, legal update. Again, there is a case in Supreme Court, SK Nosad versus Union of India. Now, what happened there? Basically, there was a case wherein the employee was demanding that getting a transfer or getting a good posting, that is his right. Okay, to which the court clearly mentioned that it is not your right. All right, but there are certain cases, there are certain factors, okay, that has to be taken into consideration when an employee asks for certain posting or for some transfer. One of them is preservation of family life. Okay, so that is why the Supreme Court said that whenever the state is considering a person for transfer or for posting, or say making any policy with respect to people, they with respect to employee per se, they need to take care of the family life as well. Okay, why? Because it comes under the right to life. So basically court gave a new dimension to article 21. Article 20 talks about right to life, correct? Now there are several facets to it. One of them is this. One of them is about considering family life, preservation of family life. Okay, now why this update becomes important? Because it gives a new dimension to article 21. It is an extension to the ambit of article 21 that we have got so far. Right now there are other very important judgments also that has expanded the meaning of article 21 that you must be aware of. These are all very important case laws. First of all is right to live with human dignity, right? It's not just important to right to live, but you are also supposed to live it with a kind of dignity, right? That is being pronounced in Manika Gandhi case. Right against sexual harassment at workplace, Vishakha. This Vishakha case is very, very important. You're going to hear about it throughout your career. Okay, kahin na kisi tarike se, whenever it comes to sexual harassment, this is the first case that you're going to hear about. Okay, apart from that, right to clean environment, right? Clean air and all of that, clean water, yes, good soil, all of these are also constituted under clean environment, and this has been also validated under article 21 by Vellore citizen case. Okay, right against illegal detention in DK Basu case again is very important case. Right to legal aid, important case. Hosanara case. Right to privacy, Putta Swami case. This is like one of the very transforming case of India, right? Aadhaar yahi se bana pura. Aadhaar was validated only after this. Now, right to die with dignity. So basically, our constitution does not talk about right to death, but it talks about right to life. Okay, so if you want to die, you cannot just simply go to the court कि अभी मुझे मरने का मन है तो I just want to die, please give me permission to die, because suicide is an offense under IPC. Okay, so right to die with dignity. So it means that there are certain cases wherein a person can ask for permission of euthanasia. Okay, wherein a person asks the court that, listen, I am going through a lot of physical pain. Okay, there are instances wherein a person is going through a lot of physical pain, though it is not very easily allowed or permitted by the court. There are very rare cases wherein it is uh, actually approved, but still you can ask for right to die with dignity. When you feel that the way you are going to die is not going to be a dignified way and you want to die in a dignified manner, you can go to the court and ask for euthanasia. Okay, this is again very important case. Just few years back this was pronounced. That was Aruna's case, who was very sick. She was a lady who was very sick, and she has been enduring a lot of pain since years. And then, as the last resort, she went to the court and asked for euthanasia, and she was allowed. Okay, so that is again a very important. This is very important case. These are all important cases. You must be thorough with these cases. All right, moving on to the next legal update that talks about an amendment that is being proposed for FCRA. FCRA means Foreign Contribution Regulation Act. So, what do they do? As the word suggests, foreign contribution means there are certain institution, organization in our country who take certain foreign donation or foreign contribution. Okay, like for example, there is an NGO. Okay, if there is an NGO, or maybe I can also ask for any contribution from foreign nationals, right? Or any suppose I have an organization and that also asks for some foreign contributions. So all of these are covered under this particular act. So whenever there is any NGO, individual, or there is any other organization that is asking for, or that is taking, receiving any contribution from any foreign company, foreign national, or any foreign organization, institution, they need to register it. They need to report it. Okay. First of all, uh, there is a limit to it. All right. So if you are receiving somewhere around 25,000, up till 25,000, it is allowed that you can receive such amount with no permission. But when you are receiving any amount beyond that, beyond 25,000, you need to take a permission from Ministry of Home Affairs. Without that you cannot take it. वो illegal होगा. Okay, and especially the organization like NGOs, they are supposed to register themselves every 5 years. Okay, उनको हर 5 साल में register करना पड़ता है as to कि देखो भाई, I am going to take these foreign contributions. Okay, and I'm going to report to you everything, whatever amount we receive from foreign, we are going to give you the report of it in timely fashion. Okay, so वो एक registration भी चलता है. Now, what is the amendment talking about? So the Supreme Court basically held in a case that when an NGO is receiving any foreign donation, that is not an absolute right. वो absolute right नहीं है. Foreign NGOs cannot say that this is my absolute right, I'm going to get this donation, because Parliament can interfere into this matter. Okay, Parliament can regulate these things, right? Parliament can make laws with regard to this. Okay, so this is not an absolute right. This is what was held by the Supreme Court. Moving on to the next very famous Krishna River water dispute. Now, whenever it comes to any interstate river valley dispute, okay, there are a lot of cases, almost 6 to 7 water dispute, high level water dispute is going on between states in our country. One of them is Krishna water dispute. Now, of course, this dispute is also very important from your exam perspective. But what is important here is with regard to the legality that it brings. All right, like Article 262 of Constitution, it provides the power to the Parliament. It gives the power to the Parliament that Parliament can adjudicate upon any of these disputes. Not only that, Supreme Court can take up these matters directly. Okay, whenever it comes to any water dispute between states, Supreme Court can directly take it. But here, Parliament can also interfere. Okay, if a Supreme Court is taking any of such matter, Parliament can also interfere in these matters. Now, apart from this, what is very interesting and why this news is here on your screen. I mean, I'm providing this news to you is because two judges, okay, very famous judges of Supreme Court, Justice D.Y. Chandrachud and Justice A.S. Bopanna, both of them refused to take up this matter in the court, in their bench. Okay, not that Supreme Court cannot take the case. They said, we are not going to take up this matter. Why? Because this matter was between Maharashtra and Karnataka. Okay, and Justice D.Y. Chandrachud and Bopanna, Justice Bopanna, both of them belongs to both of them belong to the state of Maharashtra and Karnataka. So you understand what is happening? They said that since we belong to that state, okay, हमारा उस स्टेट से रिलेशन है, तेलंगाना, आंध्र प्रदेश, कर्नाटका, महाराष्ट्र, इन सब में डिस्प्यूट्स चल रहे हैं. So since we are related to those states, we may have some kind of biasness towards a particular party. Okay, so being a judge, we cannot afford to do so. We are not, it's not a moral thing to do so, right? And that is why they refused to take up this matter. Now, if you have studied about principle of natural justice, is something clicking in your mind? Yes, it's very important. Principle of natural justice is very important. So is something clicking in your mind? कुछ आ रहा है दिमाग में? There are certain principle of natural justice. Under principle of natural justice, तो कुछ हो रहा है दिमाग में, अभी कुछ याद आ रहा है? अगर नहीं आ रहा है तो these are the two principles. Okay, nemo judex in causa sua, which means that no one can be judge in his own cause. Matlab, if I have a case, suppose I have a case of there is a case of my student that is going on in a court, I am a judge there, I should not take up this course. Why? That case. Why? Because I may have a biasness towards that favorite student of mine. Yeah, because I have a personal relation with one of the litigant here, right? So I may have a biasness towards a particular litigant, a particular side. So I cannot be a judge. Apart from that, second one is audio altrum partum, very very important, and that is that before taking any judgment, both the parties has to be heard. दोनों parties को सुनना ही है. Okay, both parties should be listened by the court. Both of them should get equal and fair opportunity to present their case, and then only a particular judgment should be reached. Okay, so it basically means rule against biasness, right to a fair hearing. These are the two important principles of natural justice. So I hope ये थोड़ा click किया हो आप लोगों को. Okay, so that was it for today's session. If you have any question, if you have any legal update that you want me to discuss, please put it in the chat box. In the comment box, and I'll try to take up those topics in the next session. Yes, and thank you so much. All the very best. Take care, everybody. Also, subscribe to this channel so that when I come to take your legal update session in the next week, you at least get a notification of that. Right? Thank you so much.